Hi, everybody. I want to welcome you to our now third immigration webinar of the year. Well, I guess it's of the 12-month period since we first started doing this. It's a real pleasure to do this again for you all and have you on this webinar. I'm Justin Bregel. I'm General Counsel for the Texas Hotel and Lodging Association. We're joined again by our friends over at Monty Ramirez, founding partner Jacob Monty is going to talk to us today about immigration law as it pertains to labor and immigration enforcement in particular. I mean, it's no surprise. We're all following the news. We all know how big of an issue this is and how important it is for all businesses, but our industry, of course, as well. And so Jacob's going to give us the latest on what he's seeing, ways that we can avoid trouble, best practices for immigration, what to expect if an immigration agent comes to your hotel and starts asking for records about your employees or starts asking questions, starts to do a I-9 audit, anything else related to that in particular. Jake is in the trenches. He is all over this country representing employers, dealing with this day in, day out. And so I think you're really, really going to like what he has to share with us today. So with that, I'm going to pull up the slide deck. Jacob, feel free to.
Great. Let's get started, Justin.
Let me do some screen sharing here. All right.
Okay. Before I get started, I wanted to jump on my soapbox a little bit and talk about immigration, politics, driving while undocumented, and a few other topics. First off, ladies and gentlemen, it's been 40 years since we've had to contend with the I-9 law. IRCA, the Immigration Reform and Control Act, came into being in 1986. There hasn't been immigration reform to speak of since 86. We are way overdue. You know this, I know this. There is a huge labor shortage, and there really is a time now to get some immigration reform passed out of Congress. There's a great piece of legislation called the Dignity Act that is gaining some bipartisan traction. I encourage you all to look at that. I encourage you all to stay active with this organization. And there's others like ABIC, the American Business Immigration Coalition, your National Lodging Association. Stay active because stranger things have happened. You might say, how can this guy be talking about possible positive immigration reform? Well, look, it's been 40 years. There really is no way to go from undocumented to documented. We've seen the administration pull back a little bit in Minnesota. So, look, I think it needs to continue to be a legislative priority. I mentioned driving while undocumented. That continues to bedevil employers. Many times that's the first time you realize that your employee is undocumented, when he gets arrested because he was driving while undocumented. And now more and more local sheriffs are participating in 287G. So they're deputized as ICE agents. They stop someone for a traffic violation. They refer him to ICE. He gets detained. And all of a sudden you realize that trusted employee didn't have documentation, even though, of course, he gave you documents. You have an I-9, but those documents were fake. And there are so many fake documents everywhere. You can buy fake documents that clearly verify. Employers are fooled. And we're going to talk more about the prevalence of fake documents. But I did want to mention the issue of driving while undocumented. And that leads us to another political issue, which is, it's tempting to think, well, Trump is going after the blue states. He's in Minnesota, he was in Illinois, he was in LA. That's where the enforcement activities were. That's true. But Texas, we have borne an unprecedented enforcement that is beyond the number of undocumented workers that we have in this country. Texas has a big population of undocumented workers, but it's not near as big as California. Yet Texas has many more immigration detentions than California. So, in essence, the administration is really punishing its loyal voters because Texans voted for Trump, and yet we are getting much more enforcement and arrests than the population justifies. So take note of that. It used to be that detentions didn't automatically lead to deportations, but the administration changed their mandatory detention policy, or rather implemented a mandatory detention policy. And that means that almost everyone who gets arrested, if they entered without inspection, they're not eligible for bond. That policy is causing people to self-deport. And even though they have a viable way to challenge their deportation because they've been here longer than 10 years, because they don't have a criminal record, they're choosing to self-deport because they can't stand being locked up. With that said, let's go, Justin. Let's start this show. Next slide, please. I wanted to, okay, this is a slide I wanted to share with you because this came from your industry, and this is an example of ICE asking a hotel for records about guests. And remember, there are some Fourth Amendment issues when ICE or law enforcement asks information about guests. And in this case, they asked orally for 30 days of records regarding a number of rooms at a property. And the hotel called me, and I talked to the ICE agent. I asked for a subpoena. I said, look, we're between a rock and a hard place. We want to comply with law enforcement, but we do have some Fourth Amendment concerns also. And they narrowed the scope of the request, and we complied. We have something for our file, but this is a good thing to do. So just remember, pushing back on ICE's request for information about guests is a good idea. You don't have to fight with them about it, and they will cooperate when you push back. And in this case, they narrowed the scope of their request, and it worked out quite nicely for everyone concerned. They got what they needed, and yet we also protected our guests' privacy rights. So that is an example of how you can push back without being disagreeable. ICE was very accommodating in that way. I just wanted to share that example with you. Pushing back is good. And I know, Justin, you know a lot about the privacy interests with regard to guests. If you want to speak to that, I think it's
yeah, I mean, absolutely. So we do have an obligation to protect our guests' privacy, but and typically what we will ask, unless there's some sort of an emergency or situation, that law enforcement officers, whether it's ICE or local police or whoever, that they do produce a subpoena or warrant, for us, and we certainly have that right. But it's all about finding that right balance. Knowing what your rights are, not being scared. We see a lot of what's going on in the news in Minnesota and other places, and it's scary. But we do have rights, and we're certainly able to push where we can and ask for that documentation. There's a Supreme Court case, City of Los Angeles versus Patel, that upholds our right to our own records in a hotel. And guest records as well. So we do have that. It's a constitutional right.
Thank you. Let's go to the next slide. The one before that, the warning notice.
This one.
That one. That's the one. So this is some news I just got this week. This is a case out of Kansas that we're handling. It was a large restaurant, and you might say, why are you so proud of this? Well, I'm proud of it for a number of reasons. Number one, this is a case where the ICE fine could have been well over $100,000. The I-9s were terrible, but we showed the agent good faith. We didn't backdate any documents. We made corrections in red ink. We showed an empty head and a pure heart defense. We were terrible. The employer was terrible at I-9s, but we went in there, we made corrections in red ink, we didn't backdate any documents, and quite significantly, we had a number of employees whose work authority had been canceled by the Trump administration. We had a number of Venezuelans who had TPS, and we employed them for about almost 90 days after they had lost their authority. But Agent Jones was very accommodating. He said, look, you did employ them beyond the date authorized, but back in 2025, things were in flux. You had one court saying TPS was reinstated. It went all the way to the Supreme Court. He didn't ding us for employing those Venezuelans beyond their work authority. And again, we initially had they had produced work authority that was valid, but there was a whole battle between the administration, a court in California, and it went all the way to the Supreme Court, and the court held that the administration could cancel TPS for Venezuela. But look, I think this case illustrates that the good faith defense, when it comes to I-9 violations, is alive and well. And if you can show reasonableness, you can eliminate or reduce fines. In this case, we avoided all fines, and we're very happy about that. So I just wanted to share that as a real life example. Let's go to the beginning of the presentation now. All right. What has changed since the last time I addressed you all? Well, these are some of the changes. We now have an arrest quota of 3,000 persons per day. This is still the case. We are seeing ICE make more bold raids and investigations. The latest one being in Minnesota, which we've been following on the news, of course. We're also seeing coordinated collaboration between Social Security Administration, IRS, and Border Patrol. We're going to talk more about no-match notices. They appear to be on the verge of coming back, but whether they come back or not, we are seeing IRS error messages, and we're going to talk about what they mean. And then I already mentioned 287G, but that is local law enforcement working with ICE, and that's what's nabbing a lot of employers. That's what's nabbing a lot of employees who are getting arrested because of traffic violations and then sent to immigration. We're seeing a lot of this all over the state, especially in Austin and San Antonio, where you have immigrants that have been here for many years, no criminal background, but they are getting arrested and then referred to ICE. Lastly, ICE has more money than ever before to hire people for more bed space, and these are the big changes. Let's go to the next slide. It was just announced today that the Minneapolis, Minnesota push is being reduced or eliminated. Borders Are Homan announced that this morning, but this was a major disruption to the entire state. My law partner is in Minneapolis right now. We're handling a notice of inspection for one employer at 3 different facilities. And it is quite disruptive what's been happening over there. And I think we're going to see, hopefully we'll see ICE curtail some of that aggressive activity that we saw in Minnesota, because it also was not helpful for the president's numbers on popularity numbers. So maybe that's something that we'll see less of in 2026. Let's go to the next slide. Okay, we will see more ICE investigations, but we're not going to see as many raids. Remember, folks, that raids are expensive. Everyone talks about raids, but raids are rare. But we do see ICE investigations, I-9 investigations. And last year, in the entire country, there were around 3,000 notices of intent to inspect I-9s. This fiscal year, it's projected that there will be about 15,000. So there's a five-fold increase in I-9 audits. That's what we expect. Talked about Metro Surge, Minnesota, Social Security mismatch analysis, and IRS. Anomalies. Look, Social Security no match notices were very popular. They stopped being issued in 2021. We keep hearing that they're going to start again. But what is happening right now is the Social Security Administration is issuing error messages when you file your 1095-C under Obamacare, under the ACA. And employers should not ignore those error messages. You don't have to terminate employees with an error message, but you do have to engage in what the IRS calls the solicitation process. And that involves raising the issue with the employee and documenting that. You don't have to terminate the employee, but you do have to raise it with them. And the question becomes, well, why? Well, because even though it's an IRS rule, if you ignore that solicitation rule and ICE were to find out, and IRS were to find out about it, IRS could refer you to ICE. So that's why you need to make sure you're addressing IRS error messages. And we can talk more about that in the presentation. We have a memo that outlines what you need to do if you have an error message.
Good. Yeah.
Again, you don't have to terminate the employee, but you do have to address the issue. Was there a question there?
No, well, again, for me, I guess, and maybe we'll talk about it when we get to it. So, yeah, that documentation, I assume your checklist kind of talks about what should we document? What does that look like, right?
Absolutely, yes.
Okay. All right. Good.
Human intelligence, you have to be very careful about anonymous tips. People are reporting everyone, former employees, current employees. The hotline has always existed, but now ICE has a lot of resources to investigate and follow up on tips. Sometimes ICE will send undercover agents to apply to see if it's possible to get hired at an establishment. They're not going to do that just randomly. They're going to do that after they've gotten tips. And then there's some new AI face recognition software that's being implemented. So that's something we could see. Let's go to the next slide. That it remains to be seen what happens with regard to Minnesota. Are we going to see less of that or more of that? But again, as of today, Borders R. Homan, who's now in charge of Minnesota, indicated that the operation is over. So that promises to be good. Let's see what happens.
Yeah.
Okay, let's go to the next slide. Folks, this is a rundown of the different types of ICE activity that could impact you all as employers. Let's start with number 5, though. This is traffic stops. This is driving while undocumented. And in Texas, this is what's likely to impact you as an employer because your employees are subject to this. And we are seeing a lot of activity on this front. Again, we're not seeing raids in Texas, but we are seeing so many arrests happen because of driving while undocumented. And this is a huge problem, especially in the Austin and San Antonio area. You have DPS stopping people, you have local sheriffs stopping people, and it's resulting in a number of arrests. And oftentimes the employer, when the employee doesn't show up for work, that's the first time they get wind of the fact that this long-term employee did not have status. And it's causing a lot of disruption. Public area sweeps. Look, we've not seen this in Texas, except one area, the Colony Ridge area in Houston, which was an isolated raid, public area sweep that happened last year. Thankfully, we haven't seen this number 4 much in Texas. Hopefully, we don't see any more of those types of activities in Texas. Targeted arrests. We did number 3. We saw this at the beginning of the Trump administration last year, where aliens were being arrested at home because they had a criminal background or an outstanding deportation order. Folks, the low-hanging fruit is gone, though. The recent information from ICE indicates that 86% of the people being arrested today in the last 6 months have no criminal background or outstanding deportation order. So the low-hanging fruit is gone. Now they're really stretching and they're arresting just any of the immigrants, whether they've been here a long time, whether they have ties to the community, does not matter. So the targeted arrests have stopped, and now we're seeing more of the traffic stops and that sort of thing. Let's look at number 2, raids. Again, raids are defined as when employees are arrested at the workplace. They continue to be very rare. Very few raids happened last year, but they sometimes happen. And we're going to talk about some of the raids that have happened and what are some of the signs that could lead to a raid actually happening. And then the number 1 item, notices of intent to inspect I-9s, NOIs. This is the most common interaction you could have with ICE. I want to emphasize something. You all can help reduce your risk exposure to an I-9 audit by doing a few things. Number 1, making sure you have I-9s for all employees. Number 2, if you get a call from an innocent bystander in Kentucky that says, hey, I've never been to Brownsville or El Paso, but you guys are reporting a revenue to my social. If that happens, don't ignore that person, jump on it, investigate. If the employee still works for you, interview him. You're going to have to terminate him if he admits that the document is not his, and then get back to the innocent bystander, tell him what you did, and then there's some remedial IRS forms that have to be filed, and we can walk you through what to do, but we have a step-by-step procedure that tells you what to do. It's called the Protocol on Innocent Bystander Victims of Identity Theft. We'll make sure that Justin has it in our compliance toolkit, but it walks you through what you should do if you get an innocent bystander victim of identity theft. And it's great information. And I will say, 2 of the audits that we're handling right now are directly attributed to the employer ignoring the innocent bystander victim who came forward. So don't do that. Address the issue. Identity theft is a huge problem. That is the rundown on the ICE activity landscape. Let's go to the next slide.
All right.
Red flags within businesses. Anytime you're paying employees off the books, paying them in cash, that's a big red flag, and ICE is going to run to those opportunities. Social Security and ITIN crossover, certainly. The problem is ITINs and Social Security numbers, they both have 9 digits. So, it's hard to distinguish between an SSN and an ITIN. It is possible, but not everyone knows how to do that. What else are we seeing? Staffing issues. Sometimes employers are under the mistaken belief that they can just use a staffing company to somehow hire undocumented workers, and you can't do that. The staffing company also has to comply with the I-9 law. They have to have I-9s. Some employers, try to get around the I-9 rule, and they just say, well, we're not going to have I-9s. We're just going to call everyone an independent contractor. And of course, misclassification of workers to avoid immigration is not possible also. It's a red flag. Let's go to the next slide. Next slide, please. Okay, the I-9 has been with us for 40 years and employers are still messing up on it. What are the common errors that I'm seeing today? The Spanish I-9 is one. Folks, the Spanish I-9 is only valid in Puerto Rico. We spent 2 weeks ago, me, another lawyer, and 2 paralegals, we had to redo 400 I-9s in California because the employer had used the Spanish I-9, and that's a substantive violation. So that is something that, the Spanish I-9 is valid only in Puerto Rico. You can use the Spanish I-9 as a guide to show the employee how to complete Section 1, but it's not valid. And, it's worth going through your I-9s to make sure you're not using the Spanish I-9. What other errors do we see on the I-9? The other big one is just employers not making sure that the employee signed under Section 1. It's tempting to think, well, that's the employee's problem. Yes, it's the employee's problem, but the employer's held liable if the employee doesn't complete Section 1 and it doesn't complete it properly. So if they didn't sign, if the employee didn't sign under Section 1, that's a substantive violation that the employer is fined for. The employee is never fined in the I-9 scenario. Only the employer is fined. Employees who don't check the appropriate box indicating whether they're a U.S. citizen, an alien with limited work authority, or a permanent resident, not checking the box is a substantive violation under Section 1. Under Section 2, we see employers who fail to sign under Section 2, indicating that they looked at original documents that belong to the employee. We also see employers who fail to list the date the employee began working with the company. Both of those are substantive violations. So go through your I-9s, check your I-9s, test your I-9s before ICE does, and you'll be in good shape. Let's go to the next slide. You all have heard this presentation before. You know that you're not document experts, but you are held to the 8th grader standard. Would an 8th grader accept this document? An 8th grader would know that 2 people don't appear in one photo, that you don't get to pose for your permanent resident alien card photo as if you were in a glamour shots photo. A reasonable 8th grader knows that cleavage is not visible in a typical government photo. An 8th grader knows what a fake document looks like. This is the standard. You don't have to be a document expert, but you ought to be able to spot misspellings. You ought to be able to spot if a social begins with 666 or with a 9, it's not a real social. That's the standard. So you don't need to go overboard, and be careful about going overboard, because if you accuse someone of having a fake document and you're wrong, you're looking at a discrimination charge or lawsuit. You could be exposed on social media as having engaged in document abuse. But do remember the 8th grader standard and avoid the hall of shame. Let's go to the next slide. Now, we're going to talk about this debate over TPS, and this is what I referred to at the beginning. It's complicated, folks. You shouldn't have to call your lawyer to determine if you can hire someone or continue to employ them, but you almost need to, because oftentimes the decision made by the Department of Homeland Security Secretary is challenged by a court. And the best example of that is Haiti. Secretary Nome canceled TPS for Haiti on February 3rd. But what happened? A court said, no, that cancellation was improper. And now people with TPS from Haiti still have authority to work in the US. So this is where it gets complicated. This is where we were able to use the reasonable defense in Kansas, and that this is where the agent said, look, we're not going to fine you for continuing to employ those employees because it was reasonable and you did your best. Honduras is another example where TPS was canceled, restored by a judge, but then just this past Friday, the Ninth Circuit in California said, no, the judge was wrong, and the cancellation of TPS for Honduras is in effect again. So this is where it gets complicated. And while it's good for my business, it's not good for business, this uncertainty.
Right.
Yeah, Justin and I were talking about it. It's just not good for business. We need something more predictable. You shouldn't have to be looking at the USCIS website for a daily update. What about the poor employers? And in fact, I know a number of employers that had just restarted. They had rehired some Hondurans based on the case, and then now they have to terminate them again. It doesn't make sense. We need a predictable system, and we don't have it now. Let's go to the next slide. Folks, this is really going to impact Texas, El Salvador. El Salvador is scheduled to lose TPS in August of 2026. Will it get extended? I don't know, but there are so many Salvadorians that are embedded in this industry. They're key parts of this industry, key parts of your properties, and they could lose their work authority in September of this year. And it's a big problem. There is some hope that maybe TPS will be extended for El Salvador. Why would that happen? You might say the administration is canceling TPS. What are you talking about, Jake? Well, look, El Salvador, the president of El Salvador has a very good relationship with our president. So there are discussions, and there is some possibility that TPS could be extended for El Salvador, but this could really impact Texas. It could impact the lodging industry, the restaurant industry, and the construction industry. Folks, these TPS people from El Salvador have been here since 2001. They have homes, they have kids. They could lose their work authority in September, and this is something that we should, be aware of, and we should work with our organization and the national organizations about lobbying for this extension, because it would impact Texas. Most Salvadorians on TPS live in Texas, DC, and LA, and it's about 220,000 people would be impacted by this. So again, I wish I could give you all some definitive word on TPS, but it changes, and it really is in flux right now. So just continue to look at the USCIS website for updates on TPS. Let's go to the next slide. Remember, if ICE comes and serves you with a notice of intent, you have 3 business days to assemble your I-9s and then later present them to ICE. You don't get any brownie points for submitting them immediately. Sometimes the ICE agents will say, hey, are you sure you want the 72 hours? I could just pick them up now. It's better, always better, to take advantage of the 72 hours. It's always better to get a lawyer involved. And, this is the most likely interaction you could have with ICE. So you just know that you do have 72 hours to assemble the I-9s. Let's talk about this whole process. ICE is going to look at your I-9s. You could be fined for the I-9 errors. And then also, ICE will tell you who the undocumented workers are, and they could be and they will tell you to terminate them. That always happens in an NOI. So 2 things are possible as a result of an I-9 inspection. You could get fined. You may not get fined. It depends on what jurisdiction you're in. Sometimes they don't have the manpower to actually review all of the I-9s, and they just focus on telling you who the undocumented workers are and then asking you to terminate them. Other times they fine you for the I-9s, and they also tell you to terminate the employees that they found to be undocumented. This is how the I-9 audit process looks like. Let's go to the next slide. Fines are significant. They just went up last year. The I-9 form is now a one-page form. Again, do not use the Spanish I-9. Make sure you're using the current form for people hired as of this date. Let's go to the next slide. There is depending on what part of the state you're in, the compliance could look different. For example, in Dallas is not really looking at I-9 errors right now. They're just focusing on asking you to terminate the employees they determine to be undocumented. If ICE tells you to terminate those people, you have to terminate them. Do not rehire them via a staffing agency. Do not rehire them under a different name. If you do, that could be criminal conduct. But Dallas is not really focusing on I-9s. Houston, on the other hand, they focus on I-9s, and they're actively fining employers and also telling you to terminate the employees they determined to be undocumented. It depends on what region you're in. San Antonio has a very aggressive senior agent in charge, so immigration enforcement on the I-9 front is very aggressive in San Antonio as well. Next slide, please. Every time we talk about I-9s, the issue of E-Verify comes up. Thank God we're not in Arizona where E-Verify is mandatory, but this case illustrates how this employer was on E-Verify and they had so many undocumented workers, and this now is turning into a criminal search warrant because it seems like the manager was involved in referring people to where they could get fake documents, and he knew that they were undocumented. And this case just really blew up at the end of January, but look for more indictments on this front. It's a restaurant called Zips Sports Grill. And again, it's tempting for people to think, oh, well, I'm on E-Verify, I don't have problems. No, I like to say E-Verify is great because it's free and it doesn't work. Thankfully, we've been able to keep E-Verify from becoming mandatory in Texas. Hopefully, we're able to keep that from ever happening in Texas. But E-Verify is a myth. It doesn't work. It doesn't pick up identity theft. And it gives people a false sense of security oftentimes. Let's go to the next slide. As a result of the aggressive actions we've seen by ICE, this law firm and many others now are taking the approach that you should not copy documents the employee presents during the I-9 process. Copying has never been required, but as a result of some of the actions we've seen by ICE, ICE is trying to push back on the reasonable person standard, and they're saying, well, you employer, you should have known that the I-551 permanent resident alien card had changed. You should have spotted that this is a fake document because it didn't have the seal in this place, and you should have looked at the font. Again, that's not the standard. The standard for 40 years has been reasonable person, but because ICE is taking this aggressive or trying to take this aggressive approach, we're recommending that you no longer copy documents. If you've copied in the past, that's fine. Don't destroy those old copies, but don't copy going forward. We have a policy that lays out the justification for no longer copying. We're happy to send it to you all. It'll be in the compliance toolkit, but it's important to know about this change. We're now telling employers don't copy documents. If you are on E-Verify, you do have to copy List A documents as part of the MOU that you signed on to with regard to E-Verify. But for those of you not on E-Verify, you have the decision to copy or not copy, and copying has never been required under the I-9 law. Let's go to the next slide. Again, this is a case involving E-Verify. The employer was raided and he told the ICE agent, hey, I'm on E-Verify. The ICE agent responded, E-Verify doesn't work. And it kind of just a case that illustrates how E-Verify has some gaping holes in it. Let's go to the next slide. Okay, let's go to the next slide. If ICE were to come in and want to talk to employees or want to look for records, you should demand a warrant signed by a judge, a judicial search warrant. Most of the time, employers don't ask for any warrant and they just let them into the premises, let them talk to employees, let them take documents. And that is wrong. Employers should ask for a judicial search warrant. Search warrants are hard to get. They have to show a judge independent reasons why they believe that undocumented workers might be working at this establishment. And it has to be specific information. It's not a cakewalk to get a judicial search warrant. You should push back. You don't have to fight with ICE about it. You can just say, hey, we've been told we need a search warrant signed by a judge. I'm sure you've heard about administrative warrants being used. These are warrants much like the subpoena that's just signed by an ICE official. You need to demand a judicial warrant signed by an Article 3 judge or a magistrate. There's a difference, and we're telling employers, if ICE were to come in, and it's not just an NOI, a notice of intent to inspect the I-9s, ask for a judicial warrant. Let's go to the next slide. This case illustrates where a lot of things went wrong. ICE showed up to hand deliver an audit notice. Employees saw the ICE official and they started running. Well, it went from an NOI to an immediate raid, because if ICE sees suspicious activity, which is people running, they have authority to arrest those people or to interview them and arrest. So again, it's important that your employees know that if ICE shows up at the facility, the most common reason might be that they're a guest, number one. If they're there on official business, number two, it could be for an audit. But if employees start running, that is going to be suspicious activity that gives them cause to investigate further. So this is an example of what not to do. Let's go to the next slide. This is an example. If we go to the next slide, judicial search warrant signed by a judge. This is what you need to demand. Let's go to the next slide. Next slide, please. Next slide. Look, immigration is one of the areas where there can be criminal penalties, but it's only where you knowingly hire undocumented workers or continue to employ them. How does knowingly get established? Well, if ICE tells you as a result of a notice of intent to inspect the I-9s that certain employees are undocumented and you continue to hire them, that's knowingly. If you move those employees to a staffing company, that's knowingly. Mm-hmm. It's really hard for ICE to prove that you knowingly hired an undocumented worker because of the prevalence of fake documents that appear genuine. But when ICE tells you to terminate someone and you try to circumvent that, it's real easy for ICE to prove their point. Next slide, please. And, again, you just have to really use some common sense here. Once ICE tells you that the person is undocumented, the blinders are off. You have to no longer employ them. And that's very, very important. Let's go to the next slide. And this chart illustrates the difference between actual knowledge, constructive knowledge, and negligence. But again, it's really hard to prove employers knew. We're going to talk about other ways employers could know that someone is undocumented, IRS, 1095-C errors. This could give rise to a finding of constructive knowledge, but one notice is not enough. If the employee has gotten repeated notices and been unable to correct their Social Security information, that could lead to possible constructive knowledge. There's been no reported cases on this, but it is a red flag. Background checks. Sometimes you'll do a background check on an employee and it tells you that the Social Security number is invalid. That could be a red flag that the person is undocumented, and that could be constructive knowledge. These are things you should be on the lookout for to make sure that you haven't gotten information that should lead a reasonable person to conclude that the person is in fact undocumented. Let's look at the next slide. This is one area of the law where different people could be charged, the corporation, owners, HR people. You have to be careful. Remember, on the I-9, you're swearing under penalty of perjury that you looked at original documents that looked like the person in front of you, and those documents appear genuine on their face. Let's go to the next slide. Harboring. Harboring is much more serious than hiring. The penalties for harboring start at $250,000 per count. Harboring can include giving shelter, allowing employees to live on premises. This is why you need to make sure that any employee who lives on premises has an I-9. I recently had a case in the Midwest where the employer was allowing employees to live upstairs, but we had I-9s for these employees. They turned out to be undocumented. ICE tried to make the argument, well, you were harboring them. I said, no, we weren't harboring them. They were allowed to live upstairs. We had a lease and they were allowed to live upstairs, and we had I-9s for them. And ICE, backed off of that attempt to make a harboring charge. But harboring is very delicate. We're going to talk about this case that I've mentioned in the past, the Abby's Bakery case in the Valley, where the owners allowed employees to live on premises right next to the bakery, in a space right next door, and ICE charged them with harboring. They didn't have I-9s for those employees. They were sentenced recently, and the consequences are terrible. They're going to end up losing their business, losing their permanent residency, all because they didn't have I-9s for those employees they were allowing to live on premises. So
well, and as you know, that's so common in our industry, Jacob, for our employees in some cases to live, especially like a manager to live on the premises. It's really common for that arrangement. So I hear you on the I-9s needed.
No, I know. Yeah, that's why I wanted to cover it. It's fine as long as you have an I-9 for them.
Yeah.
It's no problem. Let's go to the next slide. This is a case that really focuses on the construction industry, but a big case that happened in Michigan and New York. And I would look for more examples of cases like this. One of the ways this case came onto the radar screen is in New York. They started to see a lot of trucks from Michigan at the different hotels, and that's what tipped off local law enforcement that there were undocumented workers from Michigan working in New York, and then presence of immigrants at the hotels is what gave rise to this investigation. That's why I included it on here. Let's go to the next slide. Next slide, please. This is the Abby's case out of South Texas, and this is the case that is really the best example of what not to do with regard to harboring. We have time for questions. I'm happy to answer any questions that Jason throws my way from the chat.
Sure. Yeah, and we haven't gotten any questions yet, folks. But if you're welcome to raise your hand or type them into the chat or the question and answer box to ask your questions. I did want to just revisit for just a second. Since the IRS error messages, you hit those again. And now going through all the slides and seeing that the knowingly or constructive knowledge is really an important element for an employer to really be hit with like a criminal action, right? What do we typically see, or what do you typically recommend when an employer gets an IRS error message? What's the recommended steps they should take?
Well, I will say, Justin, most employers have been ignoring error messages for the last 8 years. So don't ignore them anymore. Start doing what the IRS recommends. And you heard me say IRS. IRS has these solicitation rules. Follow the solicitation rules of IRS. And those solicitation rules are real clear. You have to raise it with the employee in a written format. And if you can document doing that, you've met your obligation. There's not a deadline under the IRS rules that say you have to give the employee 60 days to resolve the issue. You don't have to give them any deadline. But most employers aren't even raising the no match issue with the employer. So number one, I would say raise the no match issue.
Okay.
With the employee pursuant to the IRS regulations. After you've done that a few years, if it hasn't been solved by the employee, then maybe there's an argument that you might be put on constructive knowledge that the person might be undocumented. There's no cases indicating that that is constructive knowledge. In fact, there's some cases that say merely getting a no match notice, which is analogous to an error message, is not enough to prove constructive knowledge. But if you have sloppy I-9s and a bunch of unresolved error messages that have never been addressed, you start getting closer to constructive knowledge. I can't tell you exactly where constructive knowledge begins, but I can tell you that you should begin by addressing the error message and following IRS regulations on that.
Documentation being critical there, right?
Yes.
Okay. All right. We've got some. Okay.
Yeah, and just error messages for 2025. You'll get them sometime this year, and then you have until the end of 2026 to raise the error message with the employee. So, so you have time, but I definitely recommend that employers raise the error message with the employees.
Okay. All right. So I got a few I-9 questions here. I think I'm going to lump these two together because they're so similar. One's from an anonymous attendee, the other's from one of my friends down on the coastal bend. Basically, it has to do with the errors. And if you find mistakes or errors on the I-9, missing signatures, dates, etc., what are the steps for correcting them? Live or in your own internal audit?
Okay. Well, it depends on where the error is. If it's a Section 1 error, you're going to have to bring the employee back in. Marcelo, come. We're going through the audit. By the way, this is not an I-9 audit. This is just an internal audit that we did. We noticed you forgot to sign Section 1. Go ahead and sign it. Sign it in red ink. Put the current date that you signed it. Don't backdate it. If Marcelo didn't check the appropriate box under Section 1 as to whether he's a citizen, a resident, or an alien with limited work authority, have him check it again in red ink, and then have him date next to any changes he made to Section 1. Employers can't make any changes to Section 1. That is the domain of the employee. Now, if the errors are Section 2 errors, then the employer can make those changes. If the employer failed to list the date the employee started to work, I would put that date in red ink, put the date you made the change right next to that. And again, you use red ink and you use the current date to call attention to the fact that you weren't perfect. You had an empty head, pure heart defense. This is the essence of good faith. That's how you address most errors. You do so in red ink. You do so indicating the contemporaneous date you made the changes on, and you never backdate a document.
Okay. All right. Very good. All right. So on the I-9s, another I-9 question. Those Puerto Rican I-9s, right? The Spanish ones that are only valid in Puerto Rico, right? Let's say we have an employer here in Texas who accidentally uses one. That example you were dealing with, you said you had 400 you had to correct, right? How do you go about doing the correction there, and how do the dates work? What does that typically look like if you're going to have to fix those Spanish forms and make them English forms?
First step, you got to communicate with the employee because you don't want to cause a panic in your workforce. You don't want them to think this is an I-9 audit or a raid. You just have to show them, look, the I-9 in Puerto Rico, it's only valid in Puerto Rico. We made a mistake. If you happen to have copied documents, then you're not going to need to ask them for copies because you have copies. Again, you might say, well, Jake, it sounds like you're talking out of two sides of your mouth. No, I'm saying in the past, if you copied documents, it's good because you'll have those copies. And then you can complete section 2 as an employer because you have those copies, and you would just complete section 2 with those documents. Fixing Puerto Rican, fixing Spanish I-9s is much easier if you have copies, but I'm still saying don't copy going forward because
Right.
you're taking on a lot of risk. But in the case in California, the employer did have copies, and we were able to avoid having to ask employees to present new documents. So most of the work was done by employers, because we had the copies and we were just completing new section twos. We did have to ask the employee to complete section 1, but the
Right.
employee wasn't required to bring in new documents. And that was important because when you ask employees to bring in new documents, they're freaking out. It would have, in this case, we didn't lose any employees. We explained to them up front what had happened. We had them complete section 1 in English. We explained to them, but we didn't have to ask them to present new documents. That was very important. In this case, we were lucky we had the copies for sure. Otherwise, it would have caused a lot of disruption because employees don't have those documents anymore, or they threw them in.
Yeah.
And
Yeah.
it creates a lot of issues. In that case, we were very lucky we had the copies. But again, notwithstanding that, we're telling employers don't copy going forward. When you don't copy, you have to be better on your I-9s. You have to jot down all of the information that's required under Section 2. Oftentimes, when you copy, you can be a little sloppy. Oh, because you have a copy right there, and you can get the A number that's required under Section 2.
Yeah.
But again, that's how you remedy the Spanish I-9 problem. But it does need to be corrected, and that's
Right.
you deal with it.
And we don't backdate. We'll put the start date for their employment as their actual start date, but the date on there that on the form that we're going to sign is going to be the date we actually sign it. And then, do you recommend attaching or keeping that Spanish one as a show of good faith?
Oh yeah, absolutely. In
Okay.
fact, Justin, I'll send you all. We have it's so common. I'll send you all a little memo that we have called the Spanish I-9 memo that explains, hey, we did a self audit. We noticed this was in there.
Right.
You can keep that memo with your with the I-9s. I'll send it to you as soon as we get off the call.
Cool.
Spanish I-9 memo.
All right. We have one more question. Another I-9. What about I-9 errors for employees that are no longer working for us? How do we go about fixing those? Are we just out of luck, or what do we do?
Yeah, it's a problem because you could get fined for employees that no longer work for you. Uh, in Texas, most of the action we're seeing is on current employees. There really hasn't been a push to even audit former employees, but it is legally possible for them to audit former employees. In Texas, we're not seeing ICE do that. mainly because of funding issues. They don't have the wherewithal to look at former employees. That could change with the big beautiful bill because they're hiring more auditors, they're hiring more agents. But in other parts of the country, it is routine for them to audit former employees' I-9s also.
Wow.
Fortunately, in Texas, the focus seems to be on current employees only, but that
Yeah.
could change.
No, we can't change the past. All right. Well, Jacob, this was wonderful. Y'all, this is this webinar it has been recorded, so it will be available for you to share with your colleagues. We'll make sure we get those links out to you along with some documents that Jacob has available for us. So we really appreciate you, Jacob. I don't think this will be the last time we do this. Let's go for a round 4 at some point. We always get such high demand for this. We really appreciate it. Thanks for spending some time with us, Jacob, and being such a big advocate for our industry. We really appreciate you.
Thank you, Justin. I appreciate it.
All right, guys. Thanks, everybody. Have a wonderful afternoon.